Last time we spoke it was before Christmas of 2012, and I think we talked with Edward,
Yeah, we
Edward
did,
down
yeah.
in Te Kuiti. And I kept checking the titles to the farms every day with Linz just to make sure that what was happening, because the Crafers had removed their power of attorney, and I was wondering how this was going to be overcome. But anyway, something happened, and Peng Shing took title. All the time without cancelling the agreements that I still regard as valid contracts between myself and the Crafers. The Westpac didn't cancel the agreements. So, as far as I understand, according to land law, any agreement for sale and purchase that is not cancelled is still outstanding. And in actual fact, there is a part of the Property Law Act 2007 that gives a mortgagee whose power of sale has arisen the opportunity to cancel any sale and purchase agreements that they're not happy with, which of course they weren't happy with the sale and purchase agreements and made that pretty obvious to me. So actually I believe the situation is that I still hold the fee simple to those farms, but I couldn't actually put caveats on them anymore or do anything like that, because I got adjudicated bankrupt in May of 2012. So what I started to do was then I sold back, I had sold back to the Crafers 5 farms, and I'd sold to another guy 2 farms, and I kept sold the other 9 farms to my trust. So I think the legal position is that, and it's not being argued in court of course because nobody's made any moves to take up possession of those farms, of the Crafers or myself or the other guy who I sold them to. So the way I see it, Peng Shing has a licence from or Landcorp's actually on there running the show for the government, possibly on licence from Peng Shing. Peng Shing, on the face of it, looks like they can give that licence. It's like a share milker's contract, I suppose, and a licence to occupy. But the fee simple, I believe, is still with whomever has the right under the sale and purchase agreement that was a sub-sale to the one that the Crafers made with me. So we've moved on from straight sale and purchases to sub-sales. Okay, so that's really what's been happening with the Crafer farms. Nothing much on the surface, but it's bubbling along underneath, and one day that situation is going to have to be faced, and hopefully 2013 will be the year that it happens. So what else have I been doing? So I've been going on my merry way with the other purchases I've been making. But from now on in, when I buy a property, I'm buying it on behalf of as trustee of my trust. I'm the settlor and trustee of that trust, and so it has nothing to do with my bankruptcy whatsoever. I'm not the beneficial owner of any of those properties that I buy. But I am still buying and leasing back to vendors, so that it works as a mechanism to keep people in their properties. The courts are being extremely aggressive over all of this, still continuing to take caveats off without arguing letting the I argue my side of it, but they don't call on the judges don't call on the other side to put any arguments in reply to the arguments that I make. So it's pretty you know, not only do I argue against the bank, but I argue against the court as well. So it's unsatisfactory, but one of the very exciting insights that's come to me out of all of this is that you may or may not know that there are statuses of land. The two important status of land in New Zealand, categories of status of land in New Zealand are general land and Maori customary land. Now they're administered under two different courts, the general courts, the High Court, Supreme Court, Court of Appeal and Supreme Court administer the general land, whereas Maori customary land is administered solely by the Maori Land Court. And it also has its own act, Te Ture Whenua Māori Act, translation is Maori Land Act, which came into force in, I think it's 1991. Anyway, under that act, and the preamble to that act is a very interesting preamble that says that the Treaty of Waitangi recognises that Maori never sold any land, or it doesn't put it exactly like that, but that's the general gist of it. And under that, Maori customary land, may come as a surprise to most New Zealanders, cannot be sold for debt. That means that if the bank if Maori land has a mortgage placed on the title, the remedy, they cannot have the remedy of selling up the land for the debt. So the banks have to cut their cloth according to their means, basically. So that's what's happening with about 10%. So the other by far the largest category of land status in New Zealand is general land. And under general land is what most people are experiencing now. The banks are coming in, they're playing with the interest rates, they're playing with the finances of the country, they're playing with the economy, and they're driving people off their land by default. So but there is a way that under general land the treaty actually protects us the same as Maori have been protected by Article 2 of the treaty, and general land is protected under Articles 1 and 3. The what would you call it? The way the treaty was considered in terms of land law, since 1840 has been Article 1 gives sovereignty, or the land was ceded to Victoria, and through her family it now belongs to the Queen of England, except land that Maori wanted to keep for themselves, right? So that would be Article 2, which would be, what is now Maori customary land and has its own act. So everything else, the Queen of England says she owns it. That's the actual legal position. We are tenants, and that's why you'll see sometimes if there's any discussion about ownership of the land, you'll see you're either got tenancy in common or you've got a joint tenancy. Sometimes there'll be a co-tenancy, as in co-owners, which is a joint tenancy in that case, that's right. So let's say, so the other part of the treaty that protects general land is Article 3. That makes mention of the laws of England becoming the law of New Zealand, and that was offered to Maori as a way of using those courts if they wanted to, right? But it also, of course, applies to non-Maori that those courts that administer the land laws of England are available through Article 3 of the treaty. So what I'm putting on my sale and purchase agreements now is there's a little box on the bottom that says sail by, and it has usually licensed real estate agent, but I cross out that and I put pursuant to, it's a treaty of peaceful occupation pursuant to Articles 1 and 3 of the treaty. So, and also Section 5 of the Imperial Laws Application Act 1988, because the Imperial Laws Application Act continued to allow English land law to operate in New Zealand after we've had a series of constitutional changes down through time. But basically, the same land law operates in England as operates in New Zealand, the same history, the same precedents, etc., etc. So one very, very important thing about English land law is it's based on tenure. Now, tenure is tenancy. It's not to do, title itself is just a description of that, who's on the face of it, the tenant on there. But sometimes, for example, if you if you've got an investment property, say, and if you look at the certificate of title, you'll see that you're the joint tenant, or you're the tenant in common, or your name is there as a registered proprietor. But you have a tenant, so where do they fit into it? Well, they've got the use of it from you, but the tenure is very, very important, and that's the most important thing about land. Now, what the titles are, I believe, is they are part of a huge titles market. That's what's called the legal side, and the legal side is used extensively by government and by the banks to run the cash economy, really, because you're getting titles moving about in a market. They're also used, the titles are used in a derivatives market. They are used in a mortgage market, because that's what the charges, which are mortgages, sit upon. So there's a huge legal side out there, but there's an equitable side too, which is the use and possession of land, which sits with the tenure holders. Now, that can be in the form of you can get tenure through a sale and purchase agreement. That's a treaty. You can get tenure through a lease agreement. That's a treaty. You can get tenure through a rental agreement. That's a treaty. They're all forms of treaty, and they all sit under. And the reason, sometimes it's said that the reason that non-Maori can be in New Zealand is because of the treaty, because it's a treaty of peaceful occupation. If that weren't there, you wouldn't have sale and purchase agreements, you wouldn't have lease agreements, you wouldn't have tenancies. You might have, if Maori had chosen some other way to go, if we'd been a republic perhaps, if the French had have come along and they'd established a republic perhaps, the state would have owned all of the land, as it is the Queen of England says she owns all the land in New Zealand. But that's a story for another day. What new developments? I bought, some people might have seen what happened with a family called the Gray family down in Okato, down in North Taranaki. And the Greys sold the property to me on the 1st of March this year, 2013. I have put a caveat on, and we are now waiting to see how the bank is going to react to that. We've got some new strategies to put to them, or there's not so much strategies, but some new insights that we believe they are going to have to bite the bullet on. For example, it seems like a lot of people have not been signing what's called a mortgage instrument, which means that if they don't sign the mortgage instrument, they haven't given a mortgage. That's it in simple terms. It's really quite complex, but that's going to be something for a future time. I think people have probably heard enough about the law at the moment, but we're in good heart and things are going well. That's the main